Section 9. Legal Hotline Q&A. Arizona Fair Housing 101. Fair housing questions every Arizona broker should be ready to answer. A few weeks later, Sarah stopped by David's office with a legal pad full of notes. I've been keeping track of some of the questions buyers, sellers, landlords, and property managers have been asking me. David smiled. Welcome to real estate. The longer you're in this business, the less you'll worry about contracts, and the more you'll realize people create the biggest legal challenges. Sarah laughed. I've definitely learned that. David opened another fair housing hotline folder. Let's work through a few more situations. These are the kinds of questions brokers receive every year. Legal hotline question number 1. Seller refuses to sell to a non-US citizen. Question. During a listing presentation, a seller tells the listing agent, I don't want to sell my home to anyone who isn't a United States citizen. Can the agent accept the listing under those conditions? Answer, probably not. David explained that the Fair Housing Act prohibits discrimination because of a person's national origin. Although citizenship and national origin are not identical legal concepts, a seller's instruction to exclude buyers based on citizenship can easily result in unlawful discrimination or create the appearance of discrimination based upon a protected class. More importantly, David explained, a real estate licensee cannot participate in discriminatory conduct. If a seller insists upon violating fair housing laws, the licensee should refuse to participate and should consider declining the listing after consulting with the designated broker. Your license is never worth one commission check, David said. Arizona broker tip. If a client asks you to discriminate against a protected class, stop the conversation immediately. Explain your legal obligations under fair housing laws and involve your designated broker before moving forward. Legal hotline question number 2. Should a brokerage display fair housing information in more than one language? Question. A brokerage is located in a community where many residents primarily speak Spanish. The office displays the required fair housing poster in English. Should the brokerage also display the information in Spanish? Answer, yes. David explained that providing fair housing information in multiple languages helps consumers better understand their housing rights and promotes equal access to brokerage services. Although language alone is not a protected class under the Fair Housing Act, national origin discrimination may arise when individuals with limited English proficiency are denied meaningful access to housing opportunities in situations covered by federal law. Displaying fair housing information in both English and Spanish is considered a best practice in communities where multiple languages are commonly spoken. Broker tip: consider the communities you serve. Providing commonly used forms, notices, and fair housing information in additional languages may improve communication and customer service while reducing misunderstandings. Legal hotline question number 3. Familial status and a child living with a relative. Question. A prospective tenant applies to rent an apartment and explains that his 12-year-old nephew will be living with him while attending school. The landlord says, we don't allow children. Can the landlord refuse to rent the apartment? Answer, probably not. David explained that fair housing protections for familial status extend beyond traditional parent-child relationships. Individuals with legal custody of a child under 18, or those who have written authorization from the child's parent or legal guardian in appropriate circumstances, may also receive fair housing protection. Each situation depends on its specific facts, but a landlord should never automatically reject an applicant simply because a child will be living in the home. Arizona broker tip. Before making decisions involving children or guardianship, gather the necessary information and avoid assumptions. If questions remain, involve your broker or legal counsel before denying housing. Legal hotline question 4. Can an HOA charge fees for a service animal? Question. A tenant moves into a townhouse with a trained service dog. The Homeowners Association requires every pet owner to pay a $75 DNA registration fee to help enforce pet waste rules. Must the tenant pay the fee? David explained that under fair housing guidance, an assistance animal, including a service animal, is not considered a pet. Because the animal is part of a reasonable accommodation for a person with a disability, the HOA generally may not impose pet fees, pet deposits, pet rent, or similar charges simply because the resident has an assistance animal. Treating an assistance animal like a pet, David explained, can create a fair housing violation. Broker tip: always distinguish between household pets and assistance animals. The fair housing rules governing assistance animals are very different from ordinary pet policies. Legal hotline question number 5. HOA swimming pool rules and children. Question. An HOA rule prohibits anyone under the age of 16 from using the community swimming pool unless accompanied by an adult. A 13-year-old resident is prohibited from using the pool alone. Could this create a fair housing issue? David explained that fair housing laws prohibit discrimination based upon familial status, except in certain exempt housing, such as qualifying housing for older persons. Rules that place unnecessary or unreasonable restrictions on families with children may violate fair housing laws, particularly when children are treated differently than adult residents without a legitimate health or safety justification. Every rule should be evaluated individually based upon its purpose, reasonableness, and applicable law. The rule isn't automatically illegal, David explained, but it should be carefully evaluated before being enforced. Sarah closed her notebook. I've noticed something. What's that? David asked. The answer to almost every fair housing question seems to be, it depends on the facts. David smiled. That's why experienced brokers don't rush to answer difficult questions. They gather information. They review the law. They ask for help. Arizona broker tip. Fair housing questions rarely have one-size-fits-all answers. Before advising clients on complex issues involving disabilities, assistance animals, HOA restrictions, or discrimination concerns, consult your designated broker and, when appropriate, qualified legal counsel. Taking a few extra minutes to verify the law can prevent costly fair housing complaints later. Online discussion question 1. Why should a real estate licensee refuse to participate in a seller's request to discriminate against certain buyers? Answer. Licensees have a legal and ethical duty to comply with fair housing laws. Participating in discriminatory conduct could expose both the client and the licensee to civil liability, disciplinary action, and damage to the licensee's professional reputation. Question 2. Why are assistance animals treated differently than household pets under fair housing laws? Assistance animals provide services or support related to a person's disability and are considered part of a reasonable accommodation rather than a pet. As a result, many standard pet restrictions and fees do not apply. Question 3. Why do experienced brokers often respond to fair housing questions by gathering additional facts before providing advice? Answer. Many fair housing issues depend on the specific circumstances of the transaction. Gathering complete information helps ensure that brokers provide accurate guidance and avoid making incorrect assumptions that could create legal liability.